electronic telecommunications to avoid folks who are not invited to the court proceedings from interfering with our court proceedings. We have a password protection. The problem with that, of course, is that it prohibits the public from being able to view. Yes?
Can you help me? I can't get any audio.
Who's saying that?
And I'm in a proceeding.
Who's saying that to me?
Judge, and also let me know when we're on the record. I don't know if you want this on the record or not.
Not yet, no.
Okay, thank you.
All right, so that was our court reporter who said that?
No, that was somebody else.
Who's having a problem with audio? Please tell me who you are.
Morning, sir. I'm not sure if I
we don't have the video on, but I can hear
one moment.
Did you join with auto? You joined with auto, like when it came on, how it says join with auto?
Good morning. Can you hear me? I can hear you.
Yes, sir. I can hear you. You're logged in under CJIM1_30. What is your name, sir?
I'm sorry, sir. Hearing's not what it used to be. Could you repeat that, please?
Yes, sir. What is your name?
Charles Giannetti, sir.
Ah, all right. Good morning, sir.
Good morning.
All right. And let's see. I've got Mr. Campbell is present.
I am Ted Campbell. Can you hear me?
Yes, sir. I can hear you fine. Sir, I'm going to go ahead and ask you just to you can go ahead and leave your mute off. So instead of hitting the space bar, go ahead and click on unmute. So there you go. Perfect.
Thank you.
And yes, sir. And you're counsel for Cypress Point? Mr. Campbell, are you counsel for Cypress, or is that Ms. Fisher?
I represent the HOA. I'm president of the HOA.
All right. Ms. Fisher, are you counsel for Cypress Point?
Yes, Your Honor. And Lauren Barr is my colleague. She'll be observing.
All right. Very good. So you'll be taking the lead today. She's just going to be observing?
Yes, Your Honor.
All right. Very good. All right. And so I've got someone under the name Elizabeth Arroyo.
Yes, sir. I'm a representative of Cypress.
Okay. And who is Catherine Norris?
I'm actually checking in. I'm not sure if I actually have a trial today or not. It's for Midland funding. They were trying to cancel it.
I think they did.
Good. I didn't see it, but I wanted to make sure.
Ms. Norris, did you have a case number?
Yes, it's 2020 SC 3060.
All right, I've got Midland Funding versus Ms. Norris. And yes, ma'am, I just, 2 days ago, I received the motion to adopt settlement. So that is now off the trial docket, okay?
Wonderful, thank you so much.
Thank you, ma'am. Have a good day.
Thank you, you too.
Take care. All right, and then I have one other person signed in under 239 area code. Who do I have? It's 239 with the last 3 digits, 199. Who's present? Please unmute and tell me who you are.
Yes, hi there. Can you hear me?
I can. Good morning.
Yes, hi. It's Christine Dumas. I represent Newell Property Management for Cypress Point.
Very good. All right. Thank you very much.
Thank you.
Ma'am, now, are you just calling in? Do you have video capability, or are you just on the phone?
I am just on the phone. The link that I had was not working that I had.
All right. Ms. Fisher, were you planning on calling her as a witness?
No, Your Honor, just Mr. Kim.
Okay,
Yep.
Very good. All right. Thank you very much, ma'am. You can go ahead and mute again. Thank you.
Thank you.
And all right. So as I was saying, this whole conversation has been live streamed. The reason we're doing that, like I said, is because all of you had a password in order to get into today's proceedings. It keeps the public out, and our courts are public courts. We have to give some form of public access, and the way we can afford the public access to these electronic proceedings, but also prevent improper interference in our proceedings, was to do this live stream. I'm telling you all that because you should know that that is happening, but also I'm glad you brought a court reporter, because the live stream is not a recording, will not serve as any official court record, and will be deleted upon the conclusion of today's proceedings. All right. So with that, Madam Court Reporter, let's go ahead and go on the record. All
Okay,
right.
I'm ready, Judge. Thank you.
Thank you, ma'am. All right, we are here in the matter of Charles Giannetti versus Cypress Point Homeowners Association, 20 SC 3243. Mr. Giannetti is present. I have counsel for Cypress Point present. Counsel, please announce your presence for the record.
Audrey Fisher on behalf of Cypress Point.
Thank you, ma'am. All right, and we are here for non-jury trial. Before we begin the trial, I know you all have been to a mediation already, but I did want to have one last opportunity afforded to you if you would like to attempt to resolve this matter before going to trial. Ms. Fisher, I'm sure you're aware of this, but it's worth repeating to everybody. My job is to resolve the matter today if we go to trial, and I will. But invariably, at least one party walks away from a trial unsatisfied with the result. That is the inevitable result. Often, both parties walk away unsatisfied with the result. It's just the nature of trials. It's sort of an all or nothing kind of a deal. Settlements are not all or nothing. A settlement is a guaranteed outcome that you can live with, where you control what the outcome is. It's never going to be a win. Obviously, there's a certain amount of give and take involved, but at the end of the day, you decide how this case is going to be resolved. If you turn it over to me, A, there's absolutely no guarantee how this is going to turn out because I've neither heard the evidence nor reviewed the applicable law for it. And B, like I said, often people walk away disappointed with the outcome. So, with that being said, would the parties like an opportunity to speak privately before we begin the trial and see if there's one last opportunity to come up with an amicable solution? Ms. Fisher, would you like that opportunity?
I am always in favor of mediating and settling, Your Honor, although I think there's a very slim chance of that occurring today.
All right. Mr. Giannetti, would you like to talk to Ms. Fisher and see if you can, negotiate a settlement? If not, that's fine too.
I'm always willing to talk, Your Honor.
All right. Do you each have each other's phone numbers? Because what we can do is we can go off the record for a moment. We can mute. Because I'm not referring you back to mediation or anything like that, counsel. I just want to give you, the parties one last chance to discuss. If you're successful, great. If not, we'll begin the trial immediately. Mr. Fisher, can you maybe give, Mr. Giannetti, could you give Ms. Fisher your phone number and she can call you?
Sure. It's 203-261-7923.
Okay, excellent. I'll give you a call shortly.
All right, well, I'm gonna go ahead and mute everybody. Madam Court Reporter, we're gonna go off the record for a moment. I'm gonna stay here. So just come back and let me know if you've got a resolution, great. And if not, we'll start our trial. All right.
Are you going to call me?
No, sir. Oh, yes, she's gonna call you, and then whatever your discussions lead to, one way or the other, let me know, and I'll be right here. Okay?
Right. Thank you.
Thank you.
Madam Court Reporter, I didn't catch your name.
Yes, I'm Pamela Roloff, Roloff like Frank, with Veritext.
Thank you.
You're very welcome.
Judge Brown, we're ready when you are.
All right. All right.
Unfortunately, we're not able to reach a resolution.
No
Back
problem.
on the record, Judge?
Yes, let's please go back on the record. Thank you. All right. Mr. Giannetti, would you please go ahead and turn your microphone back on?
Oh, unmute. Okay.
There we go. All right. All right. So we are back on the record, and so we're going to go ahead and proceed to a trial at this time. Mr. Giannetti, let me explain to you how a trial works, okay?
Sure.
Because you are the plaintiff, you carry the burden of proof, and that burden is called a preponderance of the evidence, all right? Because you carry that burden, you'll need to present evidence, an argument that outweighs whatever the defense may or may not present. So you are free to testify on your own behalf. I don't believe you have any witnesses present that you would otherwise call. I did not see any documents or other exhibits that you wish to have entered. Did you submit anything prior to today's hearing?
Yes, sir. Yes, Your Honor. I gave the documents to the, whatever they are, down in the...
my clerk has them.
Excuse me?
My clerk has them, but I don't. Are they electronically scanned, Heather? Are you able to?
Let me check. Yes, Your Honor. They were scanned.
So they're in showcase. I can view them there.
Yes, it's line 20.
Okay. All right, sir. As we get to a document that you wish to enter, Ms. Fisher, did you get a copy of Mr. Giannetti's submission?
I did get copies of some records. I'm not 100% sure that it's the same that was submitted to the court.
All right, then what I found is the best way to do this is as we reach a document that you wish to enter, sir, I'll do a screen share so Ms. Fisher can see what I'm looking at and raise any objections she sees appropriate at that time. When your case is concluded, sir, Ms. Fisher will be able to present whichever evidence, documents, argument she wishes. And then you'll have an opportunity for a brief rebuttal. Both sides will then have a chance for closing argument, okay? Do you have any questions about how the trial is going to proceed, sir?
Only that the exhibits, will they be marked and then by plaintiff or defendant, or how is that?
Well, what we will do, if they're not pre-marked, I've got stickers. So what I will do is I will print them out and mark them appropriately and submit them to the clerk.
Okay, no, they weren't pre-marked, Your Honor.
No problem. Then I can print them out as we get to them if they're being entered into evidence, and I'll mark them and I'll submit them to the clerk at the end of our proceeding.
Yes, sir.
And I do have a quick question. I did notice there was an exhibit filed by the defense where there's some correspondence that indicate that you might be a doctor. Would you prefer to be referred to as your formal title, sir? Would you prefer that I address you as Dr. Giannetti or as Mr. Giannetti acceptable?
It doesn't matter, Your Honor. You could use either title.
Okay, I just as a matter of respect. So I just want to make sure, some people do have a strong preference. All right, are both sides ready to proceed?
Yes, sir.
All right, Ms. Fisher, who do you intend to call as a witness?
Mr. Ted Campbell is president of Cypress Point.
Very well. Mr. Campbell, Mr. Giannetti, would you both please raise your right hands? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, very well. Please put your hands down. All right. Mr. Giannetti, please tell me why we're here today. Why do you believe you're entitled to the relief sought in your complaint?
Well, as I have stated on the Small Claims Forum, the defendants have violated the declaration of covenants and conditions and restrictions of the homeowners association.
I'm sorry to interrupt. Heather, the documents that's in line 20, that's from the defendant. There's a notice of trial exhibits filed by the defense. So the documents that you are holding in your hand, is it 88 pages?
I'm sorry, sir.
No, I'm sorry. I'm talking to the clerk real quick.
Not sure how many pages. I'd have to count them, but you know, it doesn't really look like 88 pages.
All right, that must be Mr. Giannetti's. Is there a way for you to scan that and upload that to showcase
Sure.
it away? Thank
Sure.
you. Sorry for the interruption, sir. I want to make sure that we've got the exhibits so when we go through the trial, I can see what you want me to see. All right, so while she's doing that, go ahead, sir. Please continue. I'm sorry for that interruption.
That's okay, Your Honor. But I only have about, I think it was 20 something pages. She said 88, so.
The submission by the defense was 88 pages. So I just want to make sure that.
I'm sorry, I missed that, defense. So the first, are we going to, just for my own to note on here, is the defendant going to, or the plaintiff going to be like ABC or 1, 2, 3, or how's that going to go?
For documents, my preference, I always prefer to refer to them by number because there's only, I don't think we're going to get there in this case, but there's only 26 letters in the alphabet. And I used to try cases that were kind of complex. And when, it gets really confusing once you get to the 27th exhibit. So it's just always been my practice to use numbers.
So it will be just consecutive numbers for each side, or it will be like, will there be a notation saying like plaintiff 1 and then defendant 4 or something like that?
Correct. Yes, sir. And that way we have accurate references for the record.
Okay, so this would be plaintiff 1, I guess. Then,
well, start by just sort of giving me a summary of why we're here. So I understand when you're showing me these exhibits, I'll have a big picture understanding of why we're having this trial today.
Well, Your Honor, the summary is very simple, that they have violated the document, the provisions of the documents, and that in conjunction with those violations, they have committed unfair and deceptive practices. That's basically it in a nutshell. There's really only one specific provision that's been violated. So it's very simple.
Okay.
The rest of the information will relate to correspondence, et cetera, about the claims that the homeowners association made, claims of deficiencies, et cetera.
Okay.
If you want me to, if I give a summary, I'm going to say what I'm going to say now, but.
Okay. Well, go ahead and proceed then.
Okay. So the first exhibit is the amended and restated declaration of covenants, conditions, and restrictions for Cypress Point. I'm just want to submit the face page and the one provision that I'm going to cite. The defendant has apparently submitted the entire document. So unless it's necessary to do that now, it would be available to the court, obviously.
Sure.
The defendant.
Until I get these documents uploaded, counsel, where in your submission, do you know which part, are you referring to the homeowners association, the covenants? Is that what we're referring to?
Are you Are you speaking to the defendants?
Yes,
Or-
I'm just trying to figure out what we're referring to.
Yeah,
It's just that, so it's declarations and covenants. I guess we're talking about 6.2 and 8.9, is that right?
that's what the defendants referred to, yes.
All right. Counsel, is that really what's at issue and do? I said, I'm waiting for the upload to happen so I can see the plaintiff's documents. But
We did submit the entirety of the declaration, Your Honor, because we're talking about a fine under one section and then enforcement under another.
okay.
So the entirety of the document is, it starts with certificate of amendment cover page in our submission.
All right. Do you know roughly where in your submission that is?
The e-service I have came across as 4 or 5 separate emails. So it's on page 16 of 20 on the third to last.
Okay.
I don't know if that's helpful.
No, but that's okay. All right, here is I found the certificate of amendment, and there's an amended and restated declaration of covenants, conditions, and restrictions for Cypress Point.
Yes, Your Honor.
All right, and so and that's and you submitted it in its entirety.
Yes, sir.
All right. So it sounds like Mr. Giannetti wishes to admit, at least the page or pages addressing section 6.1 and 8.9. Defense counsel, do you have any objection to those portions of the declarations and covenants being admitted as plaintiffs 1?
No, Your Honor, so long as we can admit the remainder at a later point.
Absolutely, that's fine.
I didn't get that, Your Honor, sorry. What did she say?
What we're going to do, sir, by stipulation, I think, if you agree with this, sir, the defense has submitted as a proposed exhibit the entirety of the covenants and declarations. Do you have an objection to the entirety of the covenants and declarations being admitted? And then you can refer to any portions of it that you wish.
No objection, Your Honor.
All right, then for the record, the entirety of the covenants and declaration will be admitted as defense composite 1. And I will print that out and mark that for the clerk's office. All right, sir, so now you're free to refer to any portions of the covenants and declarations that you see fit.
Thank you.
All right, go ahead, please.
Basically, the only provision, as I said, I'm going to refer to as 8.9, pressure washing, which talks about roofs, driveways, sidewalks, but the key part is that they shall be pressure washed each year by December 31st as needed. And that's the crux of the matter, is that you have until December 31, each homeowner has till December 31st to accomplish those, or any pressure washing that's needed. However, on a letter dated October 21st from Palumbi Law, the homeowners association apparently, well, they didn't, it's not apparent, they had this law firm send a letter saying that your home must be, among other writings in there. This, by the way, I would admit this then as, would this be plaintiff's 1, this letter from the Palumbi Law?
It could be. Madam Clerk, I'm sorry, I know I'm asking you to scramble with this. Has this been scanned and uploaded?
Yes, Your Honor.
All right, so what I'll need to do is back out of the case and go back into it, and that should, there it is. Perfect. Now I can see it, sir. Now I can see what you've got. Thank you so much for doing that so quickly. I appreciate it.
Thank you.
All right, so sir, I'm looking at your documents. Which page are you referring to? Let me do this. I'm going to share screen, and you can tell me when I get to it.
It's a 2-page letter, both pages.
All right. Is this it? Can you see it?
That's it. That's the first page. Yes, Your Honor.
All right.
And
is that the second page?
No.
All right.
The second page is a continuation of the first page. I don't.
I'm going in order here.
Yeah, it was just the second document in after those first 2 pages of the declaration and the specific provision I referred to, 8.9. Then comes this Palumbi Law letter that has 2 pages.
Right.
The defendants may have that in their thing, maybe the second page. I don't know why it didn't show up here, but it may be in there.
I will find it.
They put it in their submissions of exhibits.
Give me just a moment.
It was stapled, and I think that's the problem. Let me go have the clerk put it in.
All right.
Thought I took the staple out, sorry.
No, it's quite all right. At some point, we'll be able to do this in a courtroom again. I promise, one day we're going to do this back in a courtroom. All right. Let me do this. Sir, the defense did submit, I think, a copy of the letter under Exhibit 3. Is that correct, counsel? The letter from Palumbi Law dated October 21st, 2019.
I know it was included in our exhibits, Your Honor, and I'm sorry I don't have them in the same order. I don't believe that you do.
No, so what I'm going to do is I'm going to do a quick screen share, and if you can confirm, Mr. Giannetti, that this is the letter you're referring to, I will just print this out and admit it as plaintiff 1, if the defense has no other objections. All right, so this is what I'm looking at. Here's the top of the letter. Can you all see it?
Yes, sir.
Yes.
And then here is the second page.
Yes.
Is that the entirety of the letter?
Yes.
Defense, any objection to this being admitted as plaintiff 1?
No, Your Honor.
All right. Then I've printed out a hard copy, and I'm going to mark it at this time. All right, go ahead, sir. What would you like me to consider with regards to this letter?
Nothing except that I thought it was unwarranted because the December 31st hadn't gotten around yet. So I still had time to do the things which I had planned on doing anyway. But as far as the letter itself goes, no, I'm not, I mean, they could say whatever they want. I'm not going to dispute the fact that they said it, but I responded to the letter a few days later, sending a letter to the president, or whatever he's called, of the board of directors of the association, telling him that the that Section 8.9 said what I've been saying several times here, that the date of compliance is December 31st, 2019. That letter is in the exhibits that I submitted.
Okay. All right, so if I understand you, you're not disputing that the pressure washing needed to get done. You just believed you had until the 31st in order to accomplish that task and still be in compliance with the rules of the HOA.
Except for the first part, it wasn't disputing it or agreeing with it. I was going to do it anyway. So that would be what I would say. I didn't dispute it, but I didn't agree with it either.
Okay.
But I did say that I had until, the key to it is, as far as I'm concerned, is that it was, whatever I did didn't have to be done until December 31st.
Okay. All right. So that brings me back to my original question when we started this is why, if I'm looking at your statement of claim, you're claiming that you're entitled to $8,000 in damages. How do you come up with that amount?
Well, if it's okay with you, sir, I'd like to continue on with the.
Oh, yes, please. Yes, please. Please continue. Go ahead.
Because the basic claim, ordinarily, if I didn't claim unfair trade practices or the other thing, the infliction of emotional distress, and well, those are the major things. If I didn't claim then this would be the end of the situation. Basically, is that just the association was erroneous in claiming that that certain things should be done at that point. So this letter I sent saying, referring to 8.9, and the response was that a copy of a letter that had allegedly been sent to me, and I never received any such letter because it was dated August 19th, 2019 from the Cypress Point Homeowners Association, and it was addressed to my Naples, Florida address. And as many people in this area, I'm not at that address in August. So I never received the letter. However, the letter, which is an exhibit, it should be the next exhibit, the letter from the Cypress Point Homeowners Association dated August 19th. Should I ask for each one of these if you have that so that we're clear on this, or what?
Yes. So let me go through these documents, see if I can find it. I'll do a share screen. We can confirm that we're talking about the same item, and then defense counsel will have an opportunity to object if she feels it's appropriate. All right. So let me do a share screen in a moment. So this is a letter from Cypress Point Homeowners Association to you on what date?
It's dated August 19th. Now in this letter,
hold on, let me find it first.
Well, it was resent, so they put a date of December 10th, 2020 on the top of it. But the letter that they're claiming they sent was August 19th, 2019.
All right, so it says August 19th, 2019 official notice of non-compliance. Is that the letter?
Yes, that is the letter, Your Honor.
All right. So let me show you what I'm looking at, make sure that we're all talking about the same thing. All right, can you see what I'm looking at here?
Could you drop that page a little?
Yes, sir.
No, the top, I have to see the top of it, because the one I put in was, as I said, resent on December 10th, 2020. That's not there either. Okay, maybe it's further on in the,
Well,
it could be further on in the
Here's December 20th, 2019. Is that it? No, not it.
No, it's just like an additional heading that was put on there for the August 19th, 2019 letter.
One moment. I think I know what you're referring to. Is this it?
That's it.
All right, but that is simply a resending of the letter that's on the next page.
Yes.
All right. Is there a second page to this, or is this it?
No, those are the only, there might have been, but I don't have it.
Okay.
The only thing I got.
All right, Mrs. Fisher, are you able to view these documents? And I would, do you have any objection to the letter being introduced as plaintiffs 2?
Not particularly, except that that is not the entirety of the letter.
All right.
There's the second page, I believe. Trying to find it in our exhibits.
Thank you very much.
Yes, Your Honor. It's about a page and a half long, so there should be one more page. I didn't see it in the documents Mr. Giannetti sent to us. It would be in
All right, so let me.
our exhibits, I believe, at page 30.
I will find it.
Okay.
Let's see. The August 19th official notice of non-compliance. Let me show you what I'm looking at here. So this is the August 19th letter. And then is this the second page of it?
Yes, Your Honor.
All right, and you're asking that you have no objection to be admitted as long as it's admitted in its entirety.
Yes, sir.
Very well. Then I'll print this out and it'll be admitted as plaintiffs 2. Hold on, let me just get the right sections. 30, 29 and 30, okay. All right, so Mr. Giannetti, I'm gonna go ahead and take a look at this letter now. Which portions or contents of this letter do you want me to look at?
Let me see. I would say that on the first page, the third paragraph down near the bottom, where it says the board of directors has identified specific conditions of your property that are not in compliance with declarations and covenants.
Okay.
Now, that is from the August 19th, 2019 letter. There is no such letter that exists from the ARC that says I'm not in compliance. And before I get to that, I'm going to go back to that in a second, but I wanted to enter an email from the Newell Property Management saying that all homes are required to be compliant by January 1st of each year. The deficiencies which precipitated the current sanctions were present on January 1st, 2019, and throughout the entire year, despite our warnings. I would like to, that's an exhibit in there. It's only a short page with an email excerpt on the top.
All right, give me something that'll help me identify it.
Stephen Folkrod.
Here we go. So it looks like, tell me if this is what you're referring to. It looks, I just see a portion of this.
It's
like a portion of an email.
Yeah, that's it, Your Honor. The rest of that page wasn't submitted. So It's only number 4.
All right. Counsel, any objection to this portion of the email being admitted at this time?
No, Your Honor.
Okay. I'll print this out. This will be admitted as Plaintiff's 3. Just a moment. While I'm doing that, please continue, sir.
Because he says in this letter that I was not in compliance on January 1st, 2019, that means there had to be something that was these deficiencies that he's referring to. I will call them imaginary deficiencies, which precipitated this thing, had to be present in 2018, because 2019 is the first day of the year, and they couldn't be in 2019. So they had to be in 2018.
I understand.
And then I will go back, then I want to go to a letter. I want to make that clear because there's going to be references to things that allegedly happened in 2018 and deficiencies according to him. And the next item I want to enter.
Before you do, I just have a very quick question.
Sure.
Mr. Campbell may be able to answer this. If counsel, you can't. Stephen Folkrode, any relationship to a Sergeant Folkrode from the Collier County Sheriff's Office that you're aware of?
I don't know.
Okay, just want to make sure. Otherwise, there could be a potential conflict that I might have. Just wanted to get that out there. All right, please continue, sir.
Is Christine still on the call? He's an employee of Newell. I don't even know him.
He's just an employee. All right. So, all right. We had a Sergeant Folkrode who was one of the supervisors in the bailiff's bureau in the courthouse for quite some time. And I just want to make sure it wasn't someone that I knew or was otherwise connected with.
Fair enough.
All right. All right. Please continue, Mr. Gianetti.
The next item is it's headed Cypress Point Homeowners Association Board of Directors meeting 11/22/19.
All right.
It's a three-page document.
What was this titled again?
I'm sorry, the title?
Yes, sir. How will I find it? How will I identify it?
Well, the top says Cypress Point Homeowners Association, and the next line is Board of Directors meeting 11/22/19.
All right.
3 pages.
Okay.
All right. Let me take a look. Go ahead and show everybody. All right. Can everyone see this? This is what you're referring to, sir?
That's the first page, sir.
All right. And then there's the second page. And it appears there's the third page. Is that the entirety of the document?
Yes, I'm sorry, I missed the second page there.
There's the second page.
Okay, fine, thank you.
All right. Ms. Fisher, any objection to this document being entered?
No objection.
All right.
If
Then,
I may add one thing, in that first paragraph, there's a typographical error at the end of the sentence of number 1. That date is 2019, not 2011.
all right. All right, but this is the document as it stands, and Ms. Fisher, you can address that with your witness when we get there.
Yes, sir.
All right. So these 3 pages then will be admitted as plaintiff's composite 4. All right, or just plaintiff's 4, not composite 4, but plaintiff's 4. All right, go ahead, sir.
What's of interest in this thing is that on the second page, where it says the owner is a chronic, it's the 1, 2, 3, third sentence down. The owner is a chronic offender with recorded offenses 2014, 2015, 2016, 2017, and 2019. There is no recorded offense in 2018.
Read the next sentence.
Hold on, sir. Mr. Campbell, it's not appropriate for you to respond. You'll have an opportunity to do so when Ms. Fisher calls you as a witness. Okay, sir?
I understand.
Thank you.
Now, the gentleman from the management company who said that the deficiencies were present on January 1st, 2019, which had to happen in 2018, says there are deficiencies, but in this document, it says there were no, I don't know about deficient, there were no offenses, which would kind of imply that there weren't any deficiencies in 2018, besides saying also at the end of that sentence, violations were not pressed in 2018. So even if there were, they weren't pressed. So that would make the sentence of the management company incorrect, erroneous. There were no offenses in 2018, period. Also, now these, by the way, they have nothing to do with what the alleged problems of 2019 are, only in that the association apparently is trying to throw in everything, including the kitchen sink, to make it look like the crime of the century. In other words, the 2019 things would still not be in effect, even if there were prior things or anything else. But this is what they said. It's prejudicial, highly prejudicial, actually. And in addition, the next document is the Cypress Point minutes. It's entitled Minutes, Cypress Point Homeowners Association for March 15th, 2018.
Hold on, let me find it.
It's just one page.
Looks like line 13.
All right, so this is the minutes of the homeowners association from what date?
March 15th, 2018.
All right, let me go ahead and share that with everybody. All right, everyone can see that? Council, any objection to this document being entered?
No, Your Honor.
All right. All right, then this will be admitted as plaintiff's 5. All right, go ahead, sir.
There's only one pertinent part here, and that is down toward the bottom where it says Ted Campbell gave the president's report. Under that, it says no current home violations in the association.
Let me take a look at that. Okay. All right. Yes, sir. Please continue.
Sure. I just was looking at one of the documents. All right, so on this just to give a reference point, the meeting of the Cypress Point hearing finding committee of December 5th, 2019, the minutes of that are proposed for admission here.
Which document am I looking at now?
The meeting of the Cypress Point hearing finding committee, December 5th, 2019.
All right.
It's only one page also.
All right, can everyone see this? And counsel, any objection?
No objection.
All right, is this just one page?
Yes, sir.
All right, this will be admitted as plaintiff's 6. Meeting of the Cypress Point hearing finding committee, December 5th, 2019. All right, yes, sir, what would you like me to look at?
No,
What is your concern with this?
What, sir?
What is it about this document that you want me to review?
Well, as I said, that's basically a reference point, but there is one thing. It says the meeting was adjourned at 9:02 a.m. The meeting it started at 9 and it was adjourned at 9:02 a.m.
Okay, why is it important to me?
I'm sorry, what?
Why is that important?
Well, because when I got there about 9:03 a.m. And I was told that the meeting had already been what do you call it? Adjourned, and that there was nothing that could be done about reopening it or anything. And I asked about rescheduling it then, and this did not, nobody was interested in doing that. The reason I did that is because, the reason that I thought that it should be rescheduled is because the board has a pattern of, for a long-term pattern, and I'll admit a bunch of meetings and proposed times for meetings, of starting meetings late.
Okay.
For example,
Before you go any further, sir, I'm sorry, Ms. Fisher, did I ask you whether or not you had any objection to this document being entered? It hasn't been entered.
To plaintiff 6, no objection.
All right. So I have this as 7. No, this is 6. I'm sorry. So this is plaintiff 6. So plaintiff 6, no objection will be entered. Yes, sir. You were saying that the board has a pattern of starting their meetings late.
Right. And I'll start with the meeting of the annual meeting of March 17th. That's a, let's see, 1, 2, 3, 4, 5-page submission. And it's the first page is Cypress Point Homeowners Association minutes, annual meeting, March 17th, 2015.
All right. Let me pull that up here. All right.
Yeah, if you go to the 5th page.
Hold on, before we do that, it looks like 2 pages.
How many?
I see 2 pages. I see, oops. I see this is the first page. Here's the second page.
Yeah.
It said, there being no further business, the meeting was adjourned at 11:55. So I see those 2 pages. Is there more to it than that?
Yeah, there's, for my exhibit, there's, let's see, 1, 2, yeah, 3 more pages.
Is this part of it?
Yes, is what part of it, Your Honor?
This limited proxy form, is this part of it? Do you see what I'm looking at?
Yes.
Okay.
And then?
The second notice of annual members meeting, is that part of it?
Yes.
And then notice of annual members meeting, is that also part of it?
Yes.
All right, is that the entirety of the document that you want to admit at this time?
Yes.
All right. Counsel, any objection to those 5 pages?
Yes, Your Honor, my objection is one of materiality. We're talking about a notice and meeting from 2015. It's not germane to the issues we're talking about today.
All right, so you have a relevance objection.
Yes, sir.
All right, sir. Relevance is defined as things that will either tend to prove or disprove a material fact at issue in this case. How does this tend to prove or disprove something that's at issue in this case?
I think it goes to that fining meeting what's the word, to not to consider a rescheduling of it because of some minor issue with time, basically. I wanted to show.
But what does this document show that addresses that issue?
It addresses the time of the meeting. The meeting was scheduled at 11 a.m. On that 5th page, it said the first notice, meeting scheduled 11 a.m.
All right, so you're wanting to do this because it shows that that back in 2015 there was a meeting that was scheduled at 11 and was gavelled into session effectively at 11:20.
Exactly.
All right, the objection is sustained. All right, please continue, sir.
Wait a minute. Does that mean it won't be admitted?
Correct.
What? Can I ask for the reason for that, or?
Because I don't see how a meeting that occurred 4 years prior to what is at issue here has any relevance or bearing on what we're addressing here. The fact they one time in the past that you can show started 20 minutes late.
Well, because
effect on the issues in this case. Please
because
continue.
I have several of those, sir, and as I said, it's a pattern. That's just the first one. I've got 4 or 5 more here that show the same thing. A pattern of starting meetings late. That's exactly what I was, I thought maybe I didn't make it clear. That's what I was trying to show, that there are many meetings that were started a lot later than the one that was 1 minute late, maybe there. No, it was maybe 2 minutes, whatever. Anyway.
All right, well, okay, what other documents do you have that show that?
Well, the next one is the Board of Directors meeting of December 10th, 2015.
Okay. There's a 9 a.m. Called the meeting to order at, it says 9 p.m., but I don't think they waited 12 hours to get started. It's probably a typo.
That's the one, yeah, that's the 9 p.m.
Okay, but I can't say for certain, I wasn't there, but
No.
Common sense would tell me that the P should have been an A, that, you know, that they didn't wait around 12 hours to get started.
That could be for that one.
Okay.
So I'll even withdraw that one.
All right.
But the next one is December 5th, 2017. The meeting, I don't have the original scheduling time, but I would submit that it would have been 10 a.m. and the meeting started at 10:10 a.m.
All right.
That's on this paper that I have here. I don't have the original date that was, the original time that was scheduled for, but these meetings always start.
All right. Well, sir, so let me ask you a question. Let's say that I accept that they have a pattern of starting a few minutes late. How does that affect your case? What difference does that make to your case?
Well, it affects it because for such a short meeting as that other one, I was a couple of minutes late and the meeting was already adjourned, that it would have been fair to reschedule the meeting and start from scratch because of all the stuff that I'm talking about today, which would have been presented at the meeting.
And let me ask you the next logical question, which is, had they done that, you know, you showed up a few minutes late and they said, "Oh, we're very sorry. We'll restart and allow you to address our meeting." How do you feel that would have changed things? How would circumstances have been different had they allowed you to do that?
Well, because I would have presented all the information that I'm presenting today. And if the court thinks that makes a difference, then it would have made a difference at that meeting also.
Oh. I can't say for certain it would have, except for the fact that whatever you're presenting today in this trial has been now in the possession of the HOA for some time and doesn't seem to change their position at all, as evidenced by the fact that we're here in trial. But
that could be true, but
okay.
You did decide.
So over defense's objection, because it looks like the remainder of this packet, Ms. Fisher, because I can't say for certain that it wouldn't have made a difference. The remainder of this packet, which was, from what I have, that's been uploaded in line 22 of exhibits, it was pages 20 through 29. These notices and times of the meeting will be admitted over objection as plaintiff 7. All right. It'd be plaintiff's composite 7. Go ahead, sir.
I'm sorry, sir. Just a couple more things, fortunately. So all of those are one exhibit, Your Honor.
Yes, sir. It'll be all those documents will be entered as one exhibit. That's plaintiff's composite 7, because they're all being introduced for the same purpose, which is, you want to show me that they sometimes start their meetings late.
Thank you.
Yes, sir.
From the defendant's submissions of exhibits, there's a letter from the president of the board here saying, well, can we bring that letter up? And I assume the defense won't have objection to their own exhibit, but.
Well, I don't know. I've got 88 pages in their exhibit, sir. So you're going to have to be a little more specific.
Okay.
What am I looking for?
It's the, let's see, 1, 2. I can give you the number of the page that it is.
Well, give me a description of it so I can find it.
It's about 30 pages in, and it's from Charles T. Campbell to me. Dated November 1st, 2019.
All right, let me do a share screen. Now this is in the packet of the submission from the defense.
Yes.
Mr. Campbell, letter dated November 1st, 2019. You wish to enter this letter as a plaintiff's exhibit, is that correct?
Yes.
Ms. Fisher?
No objection.
Okay. All right, let me print it out. All right, and this will be admitted as plaintiff's 8. Oh, and I'm out of printer paper. One moment. Sorry. All right. So I can look at it on the computer while my printer fires up here. What is it about this letter that you want me to consider?
This goes back to the material that was, the information that was presented on the alleged what do you call it? Deficiencies, the alleged violations of 2018. It goes along with the information about that. He says that there was nobody that was exempt in 2018. Therefore, I was given till November 10th, 2019. But
basically what I understood from the documents was that the HOA didn't enforce a lot of the violations because of Irma. And so they, there may have been, issues that they otherwise might have pursued. They waived any enforcement because people were getting roof replacements and things like that. That's how I read that in conjunction with some of the other correspondence.
Except that he says here, I was never exempt, and all the other evidence presented showed that there were no violations during that time. From the Architectural Review Committee and from the minutes of that March 2015 meeting, that there were no violations, because he's saying in this letter, again, it wouldn't matter if the bylaws, if they followed the bylaws or the rules and regulations, because even if they had said something in 2019, I would have had till December 31st. But he's saying in this letter, therefore, I only have till November the 10th because some alleged violations in 2018 of which there's no evidence in the whole record. So that makes it sort of troublesome. That's part of the gobbledygook and the part of the double talk that the association did to try to legitimize that 2019, those 2019 allegations.
Okay. All right. Anything else, sir?
I think this might be the final letter.
Okay.
I've made a claim for infliction of emotional distress, and
Yes, sir. Explain to me how you feel you're entitled to that. Explain to me the basis for that claim, please.
well, I'm going to try to do that now, sir. There's a letter from Cypress Point Homeowners Association on March 3rd, dated March 3rd, 2020, which is only about, I think, four or 5 pages after that other letter.
March 3rd, 2020 letter from whom?
From the Cypress Point Board of Directors.
Okay. Is this in your submission?
No, this is in, I'm sorry, I should have, I implied it, but it's in the defendant's exhibits, about 3 or 4 pages after the one we just talked about.
Okay. March 3rd, 2020 from the Cypress Point Homeowners Association. Is that it?
Yes.
All right. All right. Is this a can you see it? Is this the letter you're referring to?
Yes.
Okay. All right. Ms. Fisher, any objection to the admission of this letter?
No objection.
All right. This will be admitted as plaintiff's 9.
Okay. And I'm sorry, what?
Please go ahead, sir. Yes, sir. Please. What is it about this letter that you want me to consider?
I would like the court to consider the second paragraph.
Okay.
Which says, no one should have to endure such a long and painful process. And I certainly agree with that. And I think that goes to the support of inflicting emotional distress.
Okay.
I think I'm almost done. There was one more thing. Well, maybe it'll come up on the defense side. But if I happen to leave something out here, would I be able to present it later or not?
Not really. You will be given a chance for a rebuttal party, a rebuttal presentation if there's anything the defense presents that you wish to present in response. But this is your case. This is your chance to present whatever it is that you feel the court needs to consider.
Okay, then I think the last thing will be which is also in about the 7th, 8th page of the defendant's exhibits, the bill and the payment and the check that were paid.
Okay.
Which will be obviously we relate to damages.
see there's a statement, an invoice. Let me show you what I'm looking at. Is this what you're referring to?
Yes.
All right. And for obvious reasons, the account numbers have been redacted on the check. So, do you want this page to be admitted? Is that correct?
Yes.
All right. Counsel?
No objection, sir.
All right. So be admitted as plaintiff's 10, invoice, and check. Print that out now.
I just want to add one thing to there.
Yes, sir.
It's related to that long and painful process that was referred to in that letter, is that according to the Cypress Point Board, my privileges were revoked at that point when the fining committee made their decision back in November of 2019, and there were still a small amount of money left on my yearly amount that we have to pay for dining. I can't remember the exact word for it. Anyway, it's only $72.73, but because the committee said that the privileges are revoked, and I wasn't sure if the extent of it, and didn't want to really publicize it any more than it had already been publicized. That money wasn't spent. So I wanted to add $72.73 to the damage claim.
Okay.
Which makes the total for, I guess, actual damages $940.43, and the remainder for the emotional distress claim would then be $7,059.57.
Okay.
Slightly different than the submission that was when the case was initially entered. But this does remind me, this letter of talking about enduring such a long and painful process does remind me that fining committee activity, that's not supposed to be an open club meeting anyway. And there were other club members there, which contributed to the entire difficulty of the process. And this is, it basically, well, I wouldn't call it a circus exactly, a quiet circus, but those meetings are supposed to be closed and private and basically confidential. And none of those qualities were applied to that meeting. I wanted to put that into the record too, Your Honor.
Okay.
And basically, I think that's all I have.
All right. So to make sure I understand your position before I turn the case over to the defense, you're not disputing. Let me make sure I understand your position before I turn the case over to the defense. You're telling me you're not disputing that there were violations with regards to the need for pressure washing of the roof or walls, but you believe you had until December 31st of 2019 to remedy those issues before any sort of enforcement could take place. And because they attempted enforcement prior to that date, you believe you are entitled to a refund of any of the fines that were levied, as well as emotional damage for the whole circumstances. Is that a fair summary? of your position?
Basically, yes, except for one word, the violations. I don't think there were violations. They were just, that's the way it goes in Florida. There were just natural conditions that were present that would have been remedied. Well, remedy is not even a good word. That would have been addressed before December 31st. Yes, that's basically, otherwise what you've said is basically a good summary. Thank you.
Thank you, sir. All right, Ms. Fisher, please present your case at this time.
Yes, Your Honor, we did not invoke the rules of civil procedure, but will the court entertain an ordinance motion for involuntary dismissal?
No, because I think it's a little late to invoke the rules at this point. I think it's better we just proceed with the remainder of the trial.
No problem. By way of a brief opening statement, Cypress Point is a Chapter 720 homeowners association. It's governed by what we've introduced as Defense Composite Exhibit 1, the restated Declaration of Covenants.
Okay.
Pursuant to that declaration, Cypress Point members are responsible for maintaining the exterior of their homes at all times. The association is charged with enforcing that obligation for the benefit of all the members. Mr. Gianetti's home has been the subject of great strain on the community, and the evidence will show that he allowed mold and algae to form on his roof and on the stucco of the home, and that the association sent notice requesting that he remedy this issue. As the months passed with no response from the plaintiff, no action taken to correct it, that request had to be escalated to the association's attorney, and then eventually to the fining committee. The evidence will show that these steps were taken in accordance with the declaration. Specifically, Section 8.9 that we've discussed requires that the homes shall be free from mold and debris. So the association disputes Mr. Gianetti's description that these are natural conditions. He misunderstood, or more likely willfully defied, the obligation to keep the home clean. And he argues that he had until December 31st to remedy a situation that existed at least a year prior. Through at least 4 written communications before any fine was imposed, the association did try to persuade him to remedy the eyesore in a timely manner. Yet he's seeking recovery of the $867 in fines, as well as over $7,000 for violations of the Deceptive and Unfair Trade Practices Act, a mouthful.
Yes.
And also what he refers to in the complaint as ridicule of community damages, but he's failed to state a cause of action with regard to these allegations. And I'll explain that the fines at issue are not goods or services in commerce that would be subject to FDUPTA. There's no cognizable tort for the alleged ridicule, nor did the association take any action that would constitute any sort of defamation or infliction of distress. So I'd like to call Mr. Ted Campbell.
Very well. Mr. Campbell has already been sworn. Please proceed.
Okay. Mr. Campbell, can you please state your full name for the record?
I am Ted Campbell.
And you're a member of the board of directors for Cypress Point, is that correct?
That's correct.
What's your position?
I'm sorry.
Your position on the board?
I'm president of the board.
How long have you served as president?
I've served president, I think 4 years. I've been on the board for 6.
Okay. And what are your duties? Just a really short summary.
We're a very simple HOA because it's single family residences and no accruals and things like that for roofs. So we monitor the condition of homes, and obviously enforcement is part of it. Set a budget and maintain tree trimming and mailbox painting, and that is pretty much the extent of everything.
Does the association just send general notices to the community regarding maintenance of the homes?
What we do is try and evaluate homes the first of the year, since we have a December 31 deadline. We send out a first letter notice to people who appear to be in violation, and first letter is usually a polite one, saying we see this condition on your house. Can you get it remedied in 15 days? If we don't get a response or a correction of the condition, then we move to the second level letter, which is the Palumbi letter, which you see here. That's actually fairly rare. We've only sent a legal letter twice that I remember in the last 6 years. The other resident that got one had a roof violation. She corrected it. So this was new turf for me. We did not ever have a person before that didn't respond and correct the deficiency.
Okay. So we're talking about a specific notice sent to Mr. Giannetti, and that was introduced as Plaintiff Exhibit 2, the noncompliance notice dated August 19th, 2019. Did Mr. Giannetti, to your knowledge, receive a copy of this notice?
I believe he did. He responded with a letter.
Okay.
That indicates to me he received it.
His statement was that it was only sent to his Naples home. Is that correct?
As far as I know, Newell sends the letters. They went to both addresses, his address in Connecticut and his Naples Heritage address. And I would assume anything sent to Naples Heritage would be forwarded by the Postal Service.
I'd like to introduce photographs of the property.
Excuse me, Judge, before she does that, can we take a 5-minute break, please? We've been going over an hour and a half now.
Sure.
Thank you.
Everyone take a 5-minute comfort break. It's 10:32. We'll start back up. I'll give you a full 8 minutes. How about that?
Thank you, Judge. Appreciate it.
We'll start back up at 10:40, okay?
Thank you.
All right, thank you, everybody.
Thank you.
Okay, I'm back. Thank you.
Okay.
Thank you, Judge. I'm back. Thank you very much.
No problem. All right. I want everyone to please go ahead and unmute again, please. And I want to make sure we have our clerk back. Madam Clerk, are you there, Heather? Yep. Hello. All right. Mr. Campbell, I need you to unmute, please.
I'm sorry.
There we go. All right. Ms. Fisher, please pick up where you left off. Go ahead. Oh,
Well,
I'm sorry. And we are back on the record, yes?
Yes, thank you, Judge.
All right, go ahead.
I'd like to introduce Defense Composite Exhibit 2.
Okay, which is?
Photos taken July 8th, 2019. There are 2 pages totaling, or excuse me, 3 pages totaling 6 photos.
Okay. Now, I have to be honest with you. In my pre-trial, just quick review of the exhibits, I'll show you what I'm looking at. They did not come through very clearly. This is what I've got. So I've got 1, 2, 3 pages. Is that it?
Those are the correct photos, but you're right that those do not quite capture what we're getting at. Is there a way for me to resubmit them in color?
You can email them to my judicial assistant as long as you, if you can email them to my judicial assistant, I can pull them up as well and do a screen share so Mr. Giannetti can see what we're all looking at, if these are the same photos, but in color.
If it's easier, I could screen share them myself.
Sure, but then how am I going to get them for the purpose of an exhibit?
I'll certainly email them just for
Right.
for ease of reference. And I do have a copy of Mr.
Do you have my JA's email address?
Okay. Whenever you're ready, Judge.
I'm ready. Do you have her address?
I don't have it.
Okay. It's S Reynolds, REYNOLDS at ca.cijs20.org. And there is a color printer, but it's down the hallway from us. So what I'll have her do is I'll have her forward me the electronic image, and she'll print out the color photos. So if they get admitted, they can be part of the packet that I'll deliver to the clerk. Okay.
Okay.
I'll be right back. Let me just let her know that that's coming in. Okay. Give me one moment, everybody. All right, she has stepped away from her desk, so until she gets back, if you can do a screen share of those images, and then we'll make sure it gets part of the court record before the conclusion of the trial.
Absolutely.
All right.
As much as I've enjoyed working remotely, there are certain benefits to being in person.
I don't enjoy it at all. To be perfectly honest with you. I would much rather be in a courtroom. I'm looking forward to the day when we're able to do that. I mean, technically I'm remotely, I'm actually in chambers. I still come to the courthouse every day, but I would rather just have everybody in one room together at the same time. It's how this should be done, but we all adjust. Speaking of which, Mr. Campbell, I have a quick question while we're doing this. Is that a musket I see behind you? I was just curious.
You want this off the record, Judge?
Oh, yeah. Sorry.
Yes, it is. I have a quite large Civil War collection.
Okay, I was just curious. I couldn't help but notice it. It's actually very impressive.
I've never used it in hostility.
I would hope not. No. Sorry, I should have gone off the record.
You have good eyes, Judge. I didn't even notice that.
I spend a lot of time looking at folks on Zoom now, and so I've become sort of an informal room raider. That one caught my eye because I also noticed the uniform behind your other shoulder, sir, and I was wondering if that was, you know, a Civil War collection.
Right. I thought I had Mr. Giannetti's email to copy him, but.
There we go. Oh yeah, that is much better quality. Okay. So what we'll do, and you emailed these to Sarah, my JA?
Yes, Your Honor.
All right. Let's make sure we're back on the record, please.
Okay.
Okay, Judge.
All right. So for the record, what I'm being shown now is proposed defense exhibit, composite exhibit 2, which are the color photographs of Mr. Giannetti's home. All right. Mr. Giannetti, you're still muted. If you could unmute for me, please.
Yes, sir.
All right. Sir, do you have any objection to those color photographs being introduced at this time?
No, sir.
All right. Then they'll be admitted as Defense Composite 2. And as soon as Sarah gets back and can print those out for me, I'll mark them and be able to submit them to the clerk's office.
Okay. And my apologies to her. I sent the email with no body in it. It does have the case number here.
It's okay. So as soon as, you know, when she returns, I'll let her know.
Okay.
All right. Please continue.
Mr. Campbell, do these photos accurately reflect the condition of Mr. Giannetti's property in July and August 2019?
The photographs were taken in July, prior to our meeting and decision to start enforcement. And I would add that condition obviously didn't happen in a couple of months.
I have a quick question. July of what year?
2019.
Thank you, sir.
19.
Okay, please continue.
Okay. Mr. Giannetti's suggestion was that because you made a statement in March 2018 that there were no homes in violation, in your mind, does that necessarily suggest that his home was in compliance for the entirety of 2018?
No, I think that the context of that statement was based on the premise that we were not enforcing anything in 2018 because post-hurricane, so many homes were waiting on roof tiles and other materials for pool cages that it was literally unenforceable. So we just gave everybody abeyance for 2018.
So after the initial August 2019 notice to Mr. Giannetti, the association sent a follow-up letter, correct?
I repeat that again. I'm having difficulty hearing everything.
Sure, and it wasn't a great question, but after the August 2019 notice that was introduced as evidence already, the association sent a follow-up letter to Mr. Giannetti through its attorney, correct?
I did.
And that was, sorry, go ahead.
Well, Mr. Giannetti objected based on his premise that we had, we're not enforcing anything. And he added a second year to that non-enforcement. Besides 2018, he assumed he wouldn't be enforced in 2019. But our opinion was on January 1, 2018, or I'm sorry, January 1st, 2019, he fell into this problem because he had not cleaned throughout 2018.
Okay, Okay, so you're actually referring to a letter from me, Mr. Giannetti, to you, and that was dated October 21st, 2019. Is that right?
That's right.
Okay, and then your testimony is that that was a response to the letter from Jessica Palumbi that was introduced as Plaintiff's Exhibit 1. Let me ask a better question. I'm just trying to establish a timeline. So Jessica Palumbi's office sends Mr. Giannetti a letter in October 2019, and then you received a response personally from Mr. Giannetti, correct?
That's correct.
Okay. And
he replied October 31st, and I answered that on November 1st.
Okay. So your answer was already admitted into evidence as Plaintiff's Exhibit 3. No, excuse me, 8. But we're backing up a little bit in time. So I'd like to introduce Defense Exhibit 3. It's a letter dated October 31st, 2019.
All right. Let me do a quick screen share. Is this a letter you're referring to?
Yes, sir.
All right. Mr. Giannetti, any objection?
No, was that already admitted as an exhibit?
I don't believe so. Was it? I don't believe that was admitted as a. No, I've got a list of all the plaintiff's exhibits that was not admitted yet. All right. So without objection, they'll be admitted as plaintiff's 3. I'm sorry, defense 3. Pardon me.
Okay. So, Mr. Campbell, Mr. Giannetti's letter to you suggests that he would not have to comply until December 31st, 2019. And then what was your response?
Well, we replied the next day saying, you're not reading the letter correctly. That our letter to all members said, if you have filled out the forms for a roof replacement, you were exempt. And I don't believe we ever received any kind of an application for a roof replacement from his home. So there were also 4 other homeowners that got letters that had not filed. They all subsequently filed, got new roofs, but Mr. Giannetti did not.
Okay. So what we're talking about is sort of holding off on enforcing pressure washing of roofs. I'll call it a temporary exemption just for clarification, but what year was that temporary exemption in effect?
2018, the year following the hurricane.
So only for 2018. So if any home was out of compliance in 2018, they would have had to correct it before 2019 rolled around.
Correct. The clock expired on December 31st, 2018.
Okay. And you mentioned residents had to submit an application to the association?
No, he did not.
But to get the temporary exemption, a resident would have to submit an application, correct?
That was in my letter, yes.
Okay. And that exemption only applied to the roofs?
I strongly advised he use an insurance company to get a new roof when it was available.
Okay. But my question is more, if a resident had an exemption related to their roof because they're presumably replacing the roof due to Hurricane Irma, would they be exempt from cleaning the remainder of the exterior of the property, such as the siding, the stucco?
Absolutely. Pressure washers historically come in our neighborhood to do the roof, and they do the entire building and sidewalks and driveways. So it's a comprehensive cleaning.
Okay, so if Mr. Giannetti or any resident had an exemption for their roof, they still would have been required to remove mold and algae from the remainder of the home, correct?
Correct.
Okay. So after you responded to Mr. Giannetti sort of trying to clean up the confusion about the date that he needed to bring his home into compliance, what did the association do next?
Well, our next step was to hold a board meeting to decide how to proceed. And that was a 48-hour notification meeting. The board got together, reviewed all the evidence, and decided to move forward with a they took a motion to make a fine. That's one of the documents of that meeting. The minutes of that meeting are available in your docs.
Okay. And do you recall the date of that meeting?
I do. 2/15. 11/20, we announced the meeting, and it was held on the 22nd.
Okay, so it was with enough time after that November 10th deadline that Mr. Giannetti had to comply.
We waited till after the deadline. We also had to appoint a hearing committee, which we've never done before, in order to impose a fine. That also requires a 48-hour notice, a 14-day notice. So that hearing committee was appointed on November 15th, and the meeting was announced for December 5th. That's the one Mr. Giannetti arrived late at.
Did Mr. Giannetti have notice of the November 22nd meeting?
The notice was posted on the bulletin board as well as the sign of Cypress Point, and it was emailed to all members that we had existing emails on, which is practically all.
Does the association have an email on file for Mr. Giannetti?
We do.
So he would have received the notice of meeting by email?
He did, and he also received written notice.
After the decision to levy the fine, did the association afford Mr. Giannetti a hearing?
The hearing was established and conducted with all the 14-day notices that are required. And there was a question about it being an open meeting. Our bylaws require that. So the notice went to all members. Only, I think, 9 people attended, including the 3 committee members. It was a relatively small attended. I think 3 board members, Mr. Giannetti was there, and 3 committee members, and 2 members at large. That's established in the minutes. So it was 9 people, I believe. Not a highly public meeting.
I would like to introduce Defense Exhibit 4. It's a letter to Mr. Giannetti dated November 19th, 2019.
I'm sorry, may I get that date again from you? May I get that date one more time?
November 19th, 2019.
All right, let's see, I've got the October 31st letter, I've got the November 1st letter from Mr. Campbell. This is a letter from whom to whom? Oh, hold on. Oh,
A lot of documents.
you said this is a letter that I'm looking for?
Yes, Your Honor.
I'm looking at the letters from the law firm. I have a November 1st, 19 letter. Let's see.
In scanning through the submission to the court, I don't see that that was included, so I'll withdraw that.
Okay.
But Mr. Campbell, suffice to say, the association sent Mr. Giannetti letters and notices, so he was aware of the December 5th meeting, correct?
That's correct.
And he was aware specifically that the fining committee was considering imposing a fine, correct?
It was very well laid out what could occur at that meeting.
Okay. And he did not show up timely to that December 5th meeting, correct?
It was a very quick meeting. I didn't conduct the meeting, so I didn't have any call over whether it was adjourned, called to order immediately or not. It was. Basically, in 2 minutes, they read the charges, took a vote, and it was over.
Okay. And what was the ultimate vote?
I'm sorry?
You said they took a vote. What did they vote to do?
They voted to implement the fine, the suspension, and all sanctions that were at our disposal for non-compliance of Mr. Giannetti.
And the amount charged to Mr. Giannetti ultimately was $867.70, correct?
It was made up from a $500 in fine, and I was in error there because we could have made it $1,000 actually under the law. We only capped it at $500. In addition to that, he had a small amount of arrears on his dues, which was added in, and there was legal fees, which is under our bylaws allowed for cost of enforcement.
Okay. And Mr. Giannetti eventually paid that full amount?
He did. I think it was around the end of February of the next year.
Could the association have suspended Mr. Giannetti's membership privileges for the small amount of arrears that you mentioned he was in, unrelated to these fines?
But I'm objecting to that. What does this have to do with anything, Your Honor?
What is the relevance of that? Of whether they could have imposed some sort of sanction. What is the relevance?
The allegation is that his privileges for the community were revoked and he was damaged. And our contention is that irrespective of the fines at issue, he was in arrears anyway, and the governing documents would have allowed for a suspension in that situation.
All right, the objection is overruled. Go ahead and please answer the question, Mr. Campbell.
I don't think it makes any sense to file a lien on somebody's house over $50. So we were just letting it ride. It was gaining small interest amounts each month, and assumed that sooner or later we'd catch up and pay it.
Okay. So not that the association would have pursued a lien against him. And in fact, they didn't for the $867 that was outstanding, but they could suspend his membership privileges, correct?
That's a different amount now. Yes, that did trigger pretty every sanction in the book that we had.
Okay. Has the association broadcast these events we've been discussing? Or in other words, did they publish anything or make any statements about Mr. Giannetti's situation other than what is contained in the notices and minutes?
It was never mentioned at all to my knowledge.
Okay. And you stated the fining committee meeting was not a closed meeting, correct?
My understanding in our bylaws is we cannot hold closed meetings. It was announced to all members. However, very few attended, which is typical.
Okay. Do you have any knowledge of Mr. Giannetti's social standing in the community changing because of the events we've discussed today?
I do not associate with him very much, so I can't really comment on that.
Okay. I have no questions. If Mr. Giannetti would like to talk to Mr. Campbell.
Yes. Mr. Giannetti, you have an opportunity, if you wish, to ask Mr. Campbell some questions at this time.
Just a couple. Where in the bylaws does it say that all meetings have to be open to all members?
I'd object that that's a legal conclusion, not appropriate for a lay witness.
That's overruled because Mr. Campbell specifically testified to that fact.
Thank you.
All right, I have to go through the bylaws and find that.
So do I, but I read fast.
Nominations, elections, qualifications. This is a big document. I'll withdraw the statement if it's objectionable.
Well, no, it's been made. So the question is. where is it required in the bylaws to hold all meetings publicly, at least public to the other members?
All right. Special members meetings must be held whenever called.
Which page are you looking at?
Members may be called by members. Notice of meeting is signed by all members, including the meeting. Business of any special meeting may be limited to the items specified in the notice of meeting.
Mr. Campbell, what page are you looking at so I can follow along with you?
I'm sorry, say that again.
Which page are you looking at?
I am looking at Cypress Point Homeowners amended and restated bylaws, OR 5266, page 3694. It's near the end of the transmission, probably one of the last 10 pages in there. Amended and restated bylaws.
Right.
This is not in the declarations and covenants now. This is the bylaw.
Yes, sir, I've got that.
Where in there is it?
I'm sorry, Heather, say that again.
Where in there is it?
Okay. Amended and restated bylaws. The coding at the top of the page.
What section?
2.
Amended and restated bylaws of Cypress.
It's page 2 of the bylaws.
Well, I'm actually looking at page 3.
And the category is 3, members, meetings, and voting.
I'm looking at page 3, 3.3, notice of meetings.
3.2, special meetings.
Right. But the question is notice, and whether or not it was required to notify all members of the HOA, which apparently it does. This is Exhibit D in the defendant's submission. This is page 3 of the amended bylaws. It's 3.3, notice of meetings. The notice must be mailed or electronically transmitted to each member at the most recent address which appears on the books of the association. All right, so the bylaws actually do require notice to every member of the association. All right.
Can I comment on that now or later, Your Honor?
Later, so you can comment on that later, but if you have more questions for Mr. Campbell, please continue. But I will give you an opportunity to make a comment on that. Yes, sir.
Oh, thank you. You did send me a letter, Mr. Campbell, complimenting me on my roof, correct? The appearance of my roof.
I did. I'd like to know who did your roof. I'm only using myself.
Okay, thank you for answering that. I have no other questions, Your Honor.
All right, very good. Any redirect, Ms. Fisher?
Only one question. When did you send that letter complimenting Mr. Giannetti on his roof?
I felt that we had some justification in relieving his sanctions.
Sorry to interrupt you. My question was when. I'm curious about the timing, if it was after the fine was imposed.
That's the last letter of my file. So I believe that's the March 3rd letter.
2020, correct, sir?
Let me make sure here. All around. And having such a long and painful. That said, when you observe how pressure washing improved the look of your house, think how good the whole house would look with fresh paint. He did make efforts. I mean, and we recognize that.
Okay.
We gave him the whole month of January to get compliant, and he did some things, certainly.
Just to clarify, though, the letter that we're talking about was sent in 2020, correct?
Well, for the record,
okay, here's the letter, January 30th, 2020.
Okay.
I must compliment you on cleaning of your roof. This is the best it has looked in years. Unfortunately, the pressure washer was apparently unable to clean your house. So he had partial compliance at that stage.
Okay, thank you. No
And I
problem.
wanted to recognize that.
Okay.
Anything further, Ms. Fisher?
No, Your Honor, unless you prefer for me to make my closing now.
I'd like to give Mr. Giannetti an opportunity to present any rebuttal if there's anything along those lines. And if not, sir, you can go ahead and present your closing argument, and then I'll hear from the defense.
Should I go ahead, Your Honor?
Yes, sir. Please go ahead.
Okay. As far as that members meeting thing, I think this hasn't been brought up before, and I believe that the definition of members meeting would have to be presented. And I have to look through the whole record here to see if there are definitions of members meetings. So I don't want to really take the court's time, but I don't think a fining committee meeting is necessarily a members meeting. I was looking here. There are definitions. I would take one quick look, but you know, it's going to be, there's so many, too much areas. I would just say that I don't think that a fining committee meeting is considered a meeting that's open to all members of the club. And I'll leave it at that for now. The other thing is the letter, there were pictures shown of the house there. I'd like to enter my pictures of the house also, Your Honor.
Okay.
Your recent pictures.
Well, okay. What would that show me, and how are you going to submit it?
It would show how the house looks fine.
Well, but you're saying they're recent pictures.
Sorry?
You're saying that those are recent pictures?
Yes.
Well, I think the defense has acknowledged that you have rectified much of the issues that they had.
Oh, okay.
Mr. Campbell has acknowledged that there's been significant improvement on the condition of the exterior of the home.
Right. I just wanted to show how much improvement there was, but
okay.
If that's the entry, if that's in the record, that's fine, but.
Yes, sir. There appears to be acknowledgement by the defense that you have making significant progress on improving the issues that the HOA had.
You know what, Your Honor, though, is it possible to enter them as exhibits or not?
Well, yeah. Do you have them electronically?
No, I gave hard copies to the clerk in the court.
That was not in the packet that I received.
Not the clerk, the people downstairs, the customer service.
That is the clerk.
Okay.
That's not in the packet that was delivered to me.
Well, there were two packets, Your Honor. That was an additional submission after I saw the pictures from the defendant.
All right. Well, I don't have that, and given that it's an issue, given it's effectively a non-issue,
okay,
because they're acknowledging that you did, deal with those issues and improve them. Let's move on.
Okay. All right. The only other thing I would say, Your Honor, is all that stuff is interesting about getting letters, not getting letters and everything, which I didn't get. And of course, the post office is inefficient. I don't think at that time I was having forwarded mail. I never got a letter in Connecticut. I asked Mr. Campbell to give me all the records on the case and everything. There was only a mailing to Naples, and I don't know what happened to it, but it never got to me. However, even in view of that, it's irrelevant because, one other thing though, I would say, if there was a problem in 2018, and I think there's enough in the record now for several people, including Mr. Campbell, to say there were no violations in 2018 in the ARC, to to say there were no violations, and there was no distinction made between people who were having roofs and not having roofs or whatever. So that would cover everybody. If there was a problem in 2018, it would have had to been addressed by sometime shortly after December 31st, 2018, I would think, and it wasn't. Now, so that gets us into 2019, and no matter when, where, how, why, or what they sent, the bylaw, or actually, what is it called? It's not bylaws, it's the
Covenants and declarations.
Declaration of covenants and stuff, right? Allows until December 31st to correct those conditions, and that was done, except for a small part of the painting, which was agreed on. There'd be extra time, and that's it in a nutshell, Your Honor. That the thing that the threats and the accusations of failure to comply with the bylaws and all that stuff never should have been made, period, until if any of that stuff existed after December 31st, it could have been, but none of it did, and those should not have been made in November 2019, period. I think that's clear from the rules and regulations, or that document. We're talking the amended declaration, that one. And that is basically where I think it would stand, Your Honor.
Okay. Thank you, sir. All right, Ms. Fisher, your closing argument?
The association has shown that it imposed fines in accordance with the Declaration of Covenants. The evidence shows that the plaintiff was required to pressure wash his home in 2018. He didn't do so. He's provided generous compliance deadlines, a lot of leeway until November 10th, 2019 before any action would be taken. He willfully ignored these notices and letters. We have Mr. Campbell's testimony in the letter he sent to Mr. Giannetti dispelling any confusion as to the date of compliance. Any accusation that these letters were not sent or received by Mr. Giannetti is false, because he responded to them. He showed up at the meeting, albeit late. A brief note on the issue of open versus closed meetings. Section 4.8 of the declaration, or excuse me, the bylaws, regulates meetings where what notices are required and what meetings can be open versus closed. Under section C, in that subsection C of that section, only attorney meetings may be closed. So per the declaration, per the bylaws, the association was required to notice and have open meetings for this fining committee meeting. And the testimony is undisputed that there was no broadcast of these discussions or situation of Mr. Giannetti other than through these notices and meeting minutes. The violation notices reflect, and we heard Mr. Campbell's testimony, that the plaintiff was required to pressure wash his home by November 10th, 2019. And although they did generally delay some enforcement of roof pressure washing rules throughout 2018, to qualify for this maintenance deferral, a member was required to submit an application to the association. Mr. Giannetti did not do so. So this issue of the temporary deferral is sort of a red herring because he didn't apply. The deferral was only offered in 2018 and it only applied to the roof and not the stucco that we've been discussing. The deadline and the fine were therefore timely and proper. Florida statute section 72305 allows an association to impose fines of $100 a day up to $1,000, and the fines in this case do not exceed that statutory limit. The plaintiff has failed to show any reason he may be entitled to recover these fines that he paid.
All right, anything further?
And with regard, briefly, with regard to the FDUPTA claims, Chapter 501 regulates unfair methods of competition or unconscionable, deceptive, or unfair acts or practices in the conduct of any trade or commerce. Mr. Giannetti has not offered any evidence to suggest that he was engaged in trade or commerce with the association. The association wasn't advertising or soliciting, providing or distributing goods or service as contemplated by the definitions set forth in 501-202. And a consumer is protected under that statute, but that's someone who's engaged in the purchase of good or service. So the FDUPTA just does not apply to this case at all. None of these elements are met. He was not a consumer making a purchase in this transaction. So we're talking about violation-related fines.
Right.
Finally, the association's conduct was not unfair, not unconscionable or deceptive. That would be a violation of the statute because he was continually advised of his noncompliance, but continually advised of the potential through fines. We have notices and letters sent directly to his multiple residences as a product of this noncompliance. He was never deceived, or these fines were not undisclosed as what would be required for a FDUPTA violation. There's no evidence to suggest that he suffered from ridicule in the community or any type of tort claim that would be cognizable under an intentional infliction type claim. And there's no connection to his damages. He's suggesting that he suffered over $7,000 in emotional distress damages, but there's zero evidence to support either how that number was come to or that he was damaged at all.
Okay. Anything further?
No, sir. Thank you.
Do I have a word here, Your Honor, or?
Yes, sir. You may give one brief rebuttal response
Okay.
in closing.
First one is that section 4.8 only applies to board of directors meetings.
Okay.
Doesn't mention any other kind of meetings that have to be open. And this was not a board of directors meeting, that fining meeting. That's that one. The other one was the record is replete with deceitful practices. And I would rely on them for the what is that? FUDTPC.
Oh, what specifically was deceitful, sir?
Excuse me?
What was deceitful? How did
claiming that there were violations in 2018, and there's no record of any of those. And that's the other thing I would add in. There's no record of any violations in 2018. And even if there were, as I said, they would have to be addressed in early 2019 at the latest for the 2018 year, not let it carry over to another year. Once it carries over, even if there were, it would still not be, they still wouldn't be able to do anything in the middle of the year. I don't think, according to the rules, they'd have to give it until another December 31st, if that were true. But it's not here because there were no violations, which there's a couple of exhibits. I could point them out to you specifically. The one from the ARC and the minutes of the meeting that the president of the board there said there's no violations. So, and by the way, if there were carryover violations, he could have said, oh, well, we don't have any this year, but we haven't carried over from another year. I mean, it's absurd. Once you start getting into, well, maybe they're being very precise about the time of that meeting and everything on that, but which is meaningless, basically. And meetings have been, there's something in here, I just noticed it, about rescheduling meetings, which is a perfectly valid thing to do, but yet they're going to kind of give try to give an amorphous interpretation to a lot of specific rules, which shouldn't be applied to it. It's very clear, no problem 2019, no claim of any problem until December 31st. That's the way it should have been.
Okay. Thank you, sir. All right, I'm prepared to make a finding at this time, and I do find in favor of the defendant. There's two basic claims. There's a claim that the fines, the collection of maintenance fees, and the legal invoice was improper. Respectfully, I disagree with you, sir. The fact that the board of directors opted not to enforce violations in 2018 in recognition of the damage that a hurricane caused to the community. A waiver of enforcement does not necessarily waive violations. If there's a violation that occurs in 2018 that's not rectified into 2019, based upon my review both of the covenants and declarations as well as the bylaws, it's well within the authority of the board of directors to enforce those violations in the subsequent calendar year. An act of generosity by the board is not a waiver of all violations for that calendar year. And so there was sufficient notice throughout the calendar year of 2019, followed by correspondence, followed by a letter by counsel for the HOA, followed by notice of a meeting, where it certainly appears that at any point, if the issues were rectified, they would not have pursued any additional enforcement, as indicated by the subsequent letter in 2020 from the board of directors, where once they obtain compliance, it's quite clear that the board of directors backs right off. They're not seeking retribution, they're seeking compliance. And so I find that your claim that that upon January 1st of 2019, the slate is wiped clean for any ongoing violations, and they have to wait until 2020 to enforce them, I find that claim to be meritless, sir. I fundamentally disagree with your interpretation of these enforcement rules. Furthermore, while considering the court's finding on the first part of the claim, I don't really need to go into the second part, but I'm going to on one particular issue. Like I said, I read fast. 4.15 committees of the bylaws. This is page 7 of the amended bylaws. Board of directors may appoint from time.
A minute, Judge. Can you slow down, please?
Sorry.
Thank you. I know you can read fast, but it's
been a while since
It's
been a while since I worked with a human court reporter. If anything, I usually have electronic court reporting.
Yeah, we're human, and it's exhausting.
And we've been going for 3 hours. Your fingers get tired. I am sorry.
Right. And I have a 2 o'clock, so this was only set for an hour. So I don't know what happened there. Anyway, page 7 of the amended bylaws was the last thing I got.
Correct. Page 7 of the amended bylaws, 4.15. The board of directors may appoint from time to time such standing or temporary committees as it deems necessary or convenient for the efficient and effective operation of the association. Meetings of a committee for the purpose of taking final action on behalf of the board or to make recommendations to the board regarding a budget must be noticed and conducted with the same formalities that are required for board meetings. And all the board meetings are required to be noticed to all members. So it's quite clear that the fact that this meeting of the finding committee, the subcommittee that was appointed by the board, A, they had the authority to do so, B, they were required to notice it to the entirety of the members. I don't find that there was anything deceptive. There were no deceptive practices, nor do I really find that particular structure for bringing claims really applicable to this type of relationship anyway. And so for the foregoing reasons, I find in favor of the defendant, and the plaintiff shall take nothing from this action. So counsel, I can just do a quick judgment reflecting the finding of the court. It will just simply be a very short summary. It won't encapsulate everything I've now said because we are on the record. I think that would be sufficient to state it on the record. The judgment will just simply indicate a finding in favor of the defendant. Unless you have something else you needed added to that judgment.
We did file the notice and provided to Mr. Giannetti that we intend to seek attorney's fees in accordance with the declaration in chapter 720.
All right. The court will reserve jurisdiction to address entitlement and amount of attorney's fees.
Thank you, Your Honor.
All right. Anything further today?
Did you say there wasn't going to be a written decision on this?
There is. but it's going to be very brief. I've stated my reasons on the record, so the judgment will simply indicate that the court finds in favor of the defendant. But I will reserve jurisdiction to determine entitlement and amount of attorney's fees if sought by the defendant.
I don't know if you can answer this, but if you can, how long is the appeal period in Florida after a judgment? I can look it up if you can't answer, but.
I can't give you any legal advice, sir. I'm sorry.
Okay. I'll look that one up.
All right.
Thank you.
All right. Thank you, everybody. Have a good day.
Excuse me, Judge.
Yes.
Before you disconnect, can I give Mr. Giannetti my information in case he does want to appeal? So.
Yes, please. Because, sir, you'll need to order a copy of the transcript if you're going to file an appeal.
Okay.
Mr. Giannetti, do you know how to go into the chat?
Who?
The chat down at the bottom. If you click chat, I'll put my information and you can see it and write it down.
Okay, thank you.
Do you see it where it says chat?
Push it.
Let me put my information in for you before the judge disconnects, okay?
Okay. Hello?
Yes, sir.
Oh, are we waiting for,
Oh, there it is.
See
Can
it
you
there?
Yeah, 214.
Do you have a phone? You can, if you have a phone, you can just take a picture of it. If that'll be faster.
No, I'm not. I'm a dinosaur on that. Okay.
No problem.
Got it. Thank you.
All right, you
So
got
that's
it?
my information if you need to email me or, if you want to order the transcript, and there's all my information. Okay?
Right. I have it.
All right. Okay, very good.
Thank you, Judge.
Thank
It's
you,
been a
everybody.
pleasure. Thank you so
all.
much.
Madam Clerk, I'll get these to you right away, okay?
Okay, thank you so much, Judge.